What's up, everybody? Rob Ferretti here. Welcome to the series where I am representing myself as my own attorney, which is a pro se litigant in a federal litigation against the government. Just want to point out, just in case you're new to this, I am not an attorney, I'm not an engineer, I'm not a planner, not an architect. I am interpreting things that I see. I'm doing my own research. I'm looking at case law. Anything that you see in this video should be treated for entertainment purposes only. I do have to make it watchable, so I do trim some stuff down. It is not my intent to manipulate or misrepresent any material facts in this matter. That being said, enjoy the show. All right, everybody, Rob Ferretti here. Welcome back, episode 7. So now we've seen the overview of what's happened in the town. We've gone through what zoning is, what ordinances are, what variances are, and what everybody's role is in the process. We've gone through the baseline of what's been approved on other properties and what I knew before I came into the application process on my first application. We went through my first application, through my first resolution of denial, and then through what the guys on the planning board who voted me down on that first application have approved themselves. And that brings us here. Now we're going to go through my second application, which was ultimately approved for the house that I'm standing in, and how that played out. So we'll start with the April 23rd meeting of 2018. That is when they voted me down on my application. They denied my relief despite me reducing the garage from a 12-car garage all the way down to a 3-car slab garage with a 8-foot ceiling that could fit no more than 3 cars. So they denied me for that application, which they shouldn't have. Now, at that point, I had two options. I had 45 days to do a prerogative writ lawsuit to overturn that, which it would have been overturned. I'm confident of that. Or I could have put in a new application. I made the choice to put in a new application. So within like 2 weeks of them voting me down, I already reached out to my engineer and my architect, and I'm like, look, let's get this in with a barn and just put this to bed. Let's put my garage back, make it a garage/barn like has been approved on other properties, because there's no reason they should have denied it to begin with. But now we're removing that coverage thing that they're saying the house is too big, the garage is too big. So we revised the plans. The goal was to get the revised plans and the revised submission in prior to them passing that barn ordinance. That didn't happen. My engineer wasn't able to get the revised plans in time. And the mayor and council ultimately passed and memorialized the, I call it the Ferretti ordinance, but the ordinance requiring a minimum of 2 acres to receive any relief for calling the accessory structure a barn was on October 1st, 2018. So that brings us to December 2018, which is a full 5 months after the resolution of denial. I came in and I applied for effectively the same house and the same size garage that I originally applied for. Now, instead of playing the games at the underground tunnel, because that's what they used to deny me, that it was connected, so it was all one big structure versus 2, by separating it, that was going to be the largest change. Instead of the 3-car garage, which we ultimately retreated to on the first application, we made that back to a 36 by 40 3-car garage/barn. Now, it was a garage/barn because that is apparently what you have to call a structure in this town. Is it either a pool house or a barn? It can't be just a 3-car garage, especially for me, and still be approved. So by calling it a barn like everybody else who's ever gotten a larger structure approved than can fit 3 cars, which they've already denied me for, that was our play. Because of that ordinance that was passed, we were not seeking any relief or any lot coverage relief for the barn/garage, but we didn't feel we needed it because we were still well within the range of what everybody else with a similarly sized lot has been approved for. The other changes I made on the application is we reduced the size of the rear porch by 3 feet, and we reduced the scale of the front porch. So it was 17 by 17. We dropped it to 13.8 feet by 13.8 feet. So the smallest we could make it while still making it look proportionate, because obviously it's a historic town. You can't just put a tiny little porch on the front. You can't get rid of the porch altogether because then the house loses its visual appeal. And since the house was already approved by the historic board on the previous application, we figured why shake the boat? It makes it easier to just put in something that's already been approved without having to make further changes and continuing this cycle perpetually for no reason. The only other change we made is we reduced some of the turnaround area on the driveway to then reduce the coverage some more. And that was effectively what we were putting into the planning board, were those changes and those reductions and those modifications to the plan to therefore then put in for the second application, and then essentially corner them so that they couldn't say no, because the lot coverage that we were asking for was never an issue on anyone else's property. So the first thing to happen in the application process, again, is the historical review by the historical consultant. Now, they probably didn't speak to him prior to the review, so when we sent the application over, he reviewed it and he gave it thumbs up. And on December 15th, 2018, the historical consultant came back and said, the form of the dwellings is consistent with the zone and that the scale and massing of the dwellings were more appropriate than what were previously proposed. Now, this posed a large problem for the planning board because they relied on his letter in the resolution of denial for my house in a 3-car garage and said, this historical consultant, who we value his opinion so much, said it was too big, despite me bringing up the flaw in their logic that the historical consultant's original letter was on my initial submission before it went through the historical board and before I revised it to a 3-car garage, which is what they ultimately voted down. Now we're looking at a situation, for all intents and purposes, where he's looking at the same exact 2 structures that were initially proposed and now saying that it was appropriate. So just shows you that if he was going to be asked for his opinion on my revised plans, he would have given it a thumbs up as well, but they did not want that on the first application. They wanted to vote it down. So now they're in a situation where, like, what are we going to do if the historical consultant now says it's appropriate, and we used his opinion as a basis of why saying it was not appropriate for smaller structures in the last application? What do we do? Well, the only natural thing to do would be to have the guy change his opinion and rewrite another letter. So with no changes to the application, fast forward to January 3rd, 2019, so a couple of weeks later, and the historical consultant issued a revised letter and removed that sentence where he said the scale and massing was more appropriate than what was previously proposed. So that's, to me, very frustrating, because now you're asking an expert and you're hiring an expert for their opinion, but when you don't like their opinion, you're making them change their expert opinion so it doesn't work against what you're ultimately trying to do, which is deny me or not let me have a garage. Because if this guy says that the garage is appropriate for the zone, which is what he said in his review letter, now you have no argument. You can't disagree with the historical guy. You're trying to ride the horse of, like, this is a historical town, so we can't have these structures because it damages a historical town. But you have the historical consultant saying, no, it doesn't. You're not smarter than the historical consultant. You're hiring him for a reason, because he is the expert and you are not. So they had him get rid of that, and that pushed us forward to the historical review meeting, which was in the middle of January. Now, this is where the historical consultant actually comes to the meeting and will go through his review letter, provide his recommendations, and then the historical review board will make suggestions to the planning board if they approve the application as it is, or they may ask me to revise stuff. Obviously, they've already approved this application the way it was on the previous application, so I didn't expect the shrinking of the porches or the removal of the tunnel to change much in the way of their opinion, but it did give my neighbor the opportunity to now directly inquire and ask the historical consultant why the 2 letters had that variation, where there was initially the same 2 structures he deemed were too large, and now he's saying they're appropriate for the zone.
Alan Bell's our attorney, couldn't be here, but we did discuss this, and he asked that I see if I can get some clarification on 2 issues. The issues are related to the size of the structures, the buildings, and the trees. And I'm going to refer to your report, Mr. Dietrich, from September 8, 2017. At that time, the dwelling house was 2,073 square feet, which is still today on lease plan. And the garage was 1,440 square feet, which it also remains today, although now it's called a garage front/barn, but the building is the same exact size. In your letter on that day, in your review of the plan, under the category of form, you write the following. However, the imposing scale and massing of both the dwelling and garage in relationship to their lot are out of proportion and therefore inappropriate. As stated in the Borough Code, preservation of the rural environment of the historic district is an important function of the historic district zoning ordinance. making the relation between building and lot through appropriate scaling and massing key to preserving this rural character. So it seems to me that within the purview of the Historic Commission is the sense of size as its relationship to the lot. There's virtually no difference in the size of the garage building and the dwelling in these new plans. And yet, in your letter of 12/17/2018 on the new plans, you comment only, further, the dwelling scale and massing have been slightly reduced, which is more appropriate to the zone than what was previously proposed. And we just would like an explanation of why your answer to the same size is so dramatically different in both these assessments.
Well, it had to do with on the house itself. I took exception to the form of the porch, which I noted in that letter, and that did change. That part of the footprint did change in terms of the overall scale. I recognize that ultimately that wasn't something that was going to be or had to be pulled back because it was within the zoning, that it was being proposed. So I'm comfortable with this.
Okay. When the language is unambiguous.
That's correct.
That's a very positive, strong word. That
Yes.
It's too big. The dwelling and the garage are too big for that property. So thank you for the clarification.
Sure. I will say also just in the past that I've made such comments before, but they aren't necessarily accepted by the commission as well. So there's always a give and take. But in this case, I did feel that it was acceptable with respect to what was being.
Even though it didn't change at all in terms of the dwelling size and the garage size.
Well, I believe
beyond the porch wasn't considered.
No. But I also want to say that there were some modifications of the dormers as well that also led to this idea of a more tolerable scale.
Thank you.
And there you have it. He clarifies that they were misinterpreting his opinion. His opinion for the structures being too large on the first application, despite being on the initial application they put in where the garage was over here and the tunnel was over there, and it was the reduction of the barge board, the reduction of the porches made it more symmetrical. The dormers, which are the windows and the little roofs on it, were changed. So there were all these subsequent changes that made it then appropriate for him, which the planning board neglected to even ask him for a subsequent review letter on that. They just used his initial review letter and weaponized it as a justification for them to vote me down, even though that review letter had nothing to do with the plans that the planning board ultimately looked at. So now that we have that out of the way, the next hurdle we have to get over is the issue of res judicata. Now, res judicata was brought up by the planning board attorney first to my attorney, who's now Joe Russo instead of Ben Cassio. I replaced my attorney for the second application. And Ken Dalecki says, there's the question of res judicata that is coming up, because now they're looking for another way to try to keep me from having a garage on this property. And he says, well, res judicata, which is a doctrine that prevents the same stuff from being heard multiple times, right? And if you look through res judicata, you'll see that you just have to change something. They just don't want you to come in and say, I'd like to put my house 5 feet from the property line. I want to put up a 4,000 square foot house 5 feet from the southerly property line. And then you come back and say, okay, now I want to put up a 4,000 square foot house 5 feet from the southern property line, but I made it blue. They don't want to see the same application for relief come in over and over again. So changes have to be made. But when reading through, the changes don't have to be significant. It just has to be a different application. So if you take that same exact 4,000 square foot house and make it 10 feet from the property line, so you're moving the position of it, it could be the same exact house, but that's not barred by the doctrine of res judicata. Now, our first meeting, they were going to make it a work session regardless, so we weren't looking for a public session on the application, but we figured we could address res judicata and get that taken care of. It wasn't quite that simple.
Okay, Mr. Russo, you wish to address briefly with the board the issue of res judicata?
Yes. I have no problem acknowledging that that's the elephant in the room. Because when Mr. Ferretti first retained me, that was my question to him. How is this application different than the one that was denied? So I'm aware of it. I was aware from it from day one, and Mr. Ferretti was aware from day one. And, you know, in going over the plans, I'm of the opinion that it is substantially different than the first one. And the major difference is that in the first application, it was an application with one main structure because the garage was attached to the main structure by an underground tunnel. So all of the side yards setbacks and rear yard setbacks were triggered from the main structure. That's changed. Although the sizes of the two structures are substantially the same, the whole concept is different, where now instead of one main structure, we have a home, which is the main structure, and we have the garage/barn, which is a separate structure.
You're going to the merits of the issue. What I really want to address with the board members is whether or not the board members themselves feel that there may, I'm not saying is, may be an issue of res judicata with regard to this current application. And if the board feels there is, we need to jump to the next scheduling aspect of conducting a public hearing on that issue and allowing both sides to produce whatever argument they wish to have regarding that issue.
The reason I was going into the merits, so hopefully I can convince them today that it's not the same application, then we can just proceed to the public hearing, you know, with the issue of completeness or incompleteness on the table. That was the reason. So if you want to do it a different way, that's fine. If you want to discuss it amongst yourselves, but you know, my point was that it's a different application.
I understand that. My concern, Mr. Russo, is that at the prior application, we had a strenuous objector. Mm-hmm. I see Dr. and Mrs. McCormick here again, so I'm assuming there's an interest in this application also, and I would want to give both sides the opportunity, not just the applicant side, to produce whatever argument they wish to produce with regard to the position they like to take.
The planning board attorney loves to stretch this stuff out. So he only said, like, well, we're not going to argue the merits of it. We're just going to make a determination whether or not the planning board feels that there's enough here to justify a meeting on res judicata.
So with that,
that's the board's...
there should be some discussion among the board members as to whether or not, and ultimately a motion, I guess, whether or not the board feels that there may be an issue of res judicata, and if so, should we conduct a hearing and allow both sides to argue that issue before the board, and then the board will make a final decision on the issue.
Anybody have any input after looking at the application?
Yeah, I have input. I feel that it's the same. Pretty much when I looked at these prints, everything looks pretty much the same. A little bit of a change on the front porch. I think there was a change in the garage. Anything underground, I don't know, you know, what was changed underground, but it sure looks the same to me. The garage is the same, the house is the same. Okay.
Now, this is clearly frustrating to me because on the last application, I always argued that the tunnel doesn't impact anything because it's below grade and you can't see it, so why are we even talking about the tunnel? And the planning board only focused on it doesn't matter what it looks like above grade, it's only what it is, and it is connected. Therefore, this is one large structure, and that's why we're voting you down. So I get rid of the thing that's making it one large structure, and I come back, and they're like, it looks the same. They're legitimately reversing the argument and now saying it doesn't matter what it is, it matters what it looks like above grade. And the biggest concern or the biggest problem I have here is what it looks like above grade is completely appropriate. It's always been appropriate. When they added the two structures up and connected them underground is the only thing that made the numbers look less appropriate, but it's never something that the public was aware of or was ever going to be visible to the public. So to now take this reversing position and saying, well, it looks the same, it's clearly not the same. If we're working off of numbers, then it doesn't matter what it looks like. But if we're working on what it looks like, then it doesn't matter what the numbers are. And they take the reverse positions whenever they want. And even the other planning board members start to bring up stuff.
I would just add to that it appears to me that with the exception of the principal building lot coverage, principal building second side yard setback, and the all buildings and structures, it's virtually identical. Those are the only three items that differ, as I can see, from the original application.
So despite rattling through all the stuff that's different, it looks the same. And this is David Altman, who is his first time on the application. He was not sitting as a planning board member for my previous application. He was recently appointed. But my engineer had to jump in and be like, look, like this is a different application. There's the tunnel's not there and there's different structures.
If I may, I don't know if it's appropriate for me to talk to, okay. What happens is, following what Mr. Russo said, since there's a detachment, we have an accessory structure and primary structure, the setbacks change fairly substantially in relation to the accessory structure as was originally considered a part of the primary structure initially. So some of the other setbacks do change in that regard. Basically what I'm saying is now the accessory structure is totally compliant in setbacks with the accessory structure setbacks. So that's one aspect of it.
Well, there was no accessory structure on the first application.
Exactly, that's my point. Yes.
And not only that, it's also clarified by the planning board attorney, Ken Dalecki, who says there was no accessory structure on the previous application. So how do you even enter into a discussion of res judicata if there was no accessory structure? Now we're proposing an accessory structure. Clearly that's not going to be barred by res judicata. Regardless of what it looks like, you can't take both positions. But further discussions of the planning board made it clear that the only reason res judicata was here is because they don't want me to have a garage or they don't want me to have whatever I'm proposing. They're going to vote it down. And this was the easy way for them to just say it looks the same. We're not going to hear it again.
Okay, listen, I think we're going to have a hearing on this to decide.
Can I ask, you're the board's attorney, so I think that, I've been doing this a lot of years and I've seen some changes in applications where people came back and everything, but can you clue us in a little bit as to what the legal definition of a different application would be?
I put the standards in the review letter.
On this one? Zero it in on this one?
I'm sorry?
Did you zero it in on this one? What you feel?
Well, what I did was I tried to put what the requirements are for the doctrine of res judicata, and it's really up to the board to make a determination as to whether or not it applies to these facts, not me.
Now, I love this as well because the planning board attorney who's opining on everything, he's determining what structure definitions are on other properties. He's determining what lot coverage should be included, whether street surfaces should be included, all these determinations. But when it comes to making a BS determination on res judicata, he's got no opinion. He's just laying it out for you guys to make the decision. He's giving them the ammunition that they need to then discriminate against me. And that was what he was doing by bringing res judicata into it, was just giving them an excuse to vote me down. It had nothing to do with it, which is why he wasn't going to provide his opinion as to whether or not my application should have been barred based off of this determination. He's always got an opinion on everything except for this.
I just think we should have a hearing on it since there is multiple questions, and this way everybody can give their input and then we can make an educated decision on this. And it's going to have to be noticed in a public meeting, and then if the objectors have, input too, then we get to hear everybody and then make a decision.
Can I just leave you with this question? I don't know what else we can do. We're between a rock and a hard place. He has the right to build a home. Do we decrease the home to 1,500 square feet? Do we decrease the home to 1,000 square feet?
I don't think the home personally is the problem. That's my opinion.
If we get rid of the barn and the garage, that may be something different.
I'm just giving you my,
All right.
I think one of the problems is just the visual impact of it is actually larger than what the previous application was.
Right.
And it was knocked down because we felt it was too large. So, that's really what the case is going to be in this case. That's why I think we should have a hearing and make a decision on, whether this is pretty much the same application, because other than the underground structure being removed, which had no visible impact on the property at all anyway. That's the major reduction in your ground coverage, but.
Well, there was also the porches were both shrunk, the front porch shrunk to the smallest possible size it could be and still maintain the shape. Rear porch was drawn back, the turnaround on the driveway was removed, and then the tunnel was removed, making it 2 structures as well. And then the other thing that's influencing it is the new ordinance that was passed,
We lost 540 square feet because of the new ordinance.
which we're counting.
If we were here the last time, the 540 square feet for the barn would not be included towards the 5%. But because
If it was deemed that it was going to be
Right.
used for primarily and
because we're
exclusively
under,
for
because we're under
agriculture.
2 acres, that 540 square feet is now just part of the 5%.
Just to give some input so the board is aware, the prior ordinance stated that the barn would have to be its own separate structure. So being that it's attached to the garage, it really wouldn't have applied with respect to that prior ordinance.
That's, Greg, that's what
I agree with that.
the minute, listen, I opened the plans and I looked at that, I haven't seen anything like that we've done before. Where the barn is called a barn, but it's really not a barn, it's a connection to a garage. So it's really an addition to a garage, in my mind.
Correct. The ordinance doesn't recognize an attached
So
barn.
I want you to build a house, I want you to enjoy your home, and I just think, I hate to see, time wasted again and things going if, that's my opinion. I don't want to, I just feel like it'd be a shame to, in my mind, waste some time and money and not get there.
Okay, but being that this isn't open to the public,
Correct.
that's why I think we should have a hearing and then have it open to the public, have it discussed. I make a motion to have a hearing on this and, decide if it's this doctrine of res judicata or not. And then decide whether we're gonna hear it or not. So that's my motion. Do I have a second?
Well, before
What?
we get to a second, allow me to add to it, I think the motion should also incorporate the fact that the applicant should be required to notice for it pursuant to the municipal land use law. And if the applicant or any other interested party wishes to submit anything in writing to the board and to me, I think there should be a time period prior to the meeting that should be accomplished. In other words, not the day before, 10 days before, or something reasonable like that.
Okay.
I would think that we would require a written submission, because in large part, this turns on a legal doctrine and the application of specific facts to
Well,
this
that
legal
would,
doctrine.
Dave, that would be up to the applicant and any other interested party, whether they want to do that or not.
What happens if
Or they can rely on oral argument, period,
What
without
happens if you
anything
could come
written.
back to us with changes before we
Well,
go any
that's
further?
up to them. That's not the issue before
That's not,
now.
that's not the
I don't
issue.
know, I'm just saying,
No, that's not the issue now.
that's not the issue.
Now it's just on what's presented to us at this point.
Okay.
All right, I make that motion including what Mr. Galecki has said. Could I have a second?
I'll second that.
And a roll call. David Hanson?
Yes.
David Altman?
Yes.
Demetrius Venastanos?
Yes.
Ted Brack?
Yes.
Peter Lane, yes. Mayor Schaefer?
Yes.
And Paul Van
Yes.
Dyke.
So my attorney and I asked for a break. We went into the hallway and my attorney's like, look, you can get denied here. You can let them deny you for res judicata. Then we'll go to the Superior Court. It'll play out over 6 to 12 months. They'll overturn the res judicata thing, but that just gets you to be heard before the planning board. That doesn't even overturn the previous denial. That just makes it so they have to now hear your new application, which they can then unreasonably deny as well. And then you get to go to the Superior Court again and take another year to then have them overturn that one. You're talking it's a couple of years of fighting them to just try to get this approval. You want to live in your house, just get rid of the garage for now, save that fight for another day, and let's just focus on the house. They've got no reason to deny you for a house. You're entitled to live in the property. And that's what we ultimately came back. We came back and said, all right, we're going to amend our plans. We can see clearly what's going on. We're going to amend and come back, and we'll see you next meeting. And that should do away with all the res judicata stuff just to begin with.
After discussing this with my client and sort of reading between the lines here, we want to put it off to March 11th. For the primary reason is that we want to make some changes to this plan.
So that pushes us off to the March 11th meeting in February, in between my application. So after I submitted, but not before I submitted my revised application, the mayor and council passed another ordinance which now changes the definition of structure. So now when you're doing your house, you get a garage apron. So the distance from your garage door outward, you're allowed, it was 15 feet, that didn't count as structure coverage. Now it's 20 feet. They've also changed the allowance for patios from 200 feet to 800 square feet. And then they changed the definition of structure to no longer include mulch or decorative gravel for garden beds. Now, when you think about that, mulch used to be considered structure coverage. Now, it didn't impact my applications because I never put mulch on my applications. It was never on a landscaping plan or anything where I proposed mulch that then counted as structure. But it shows you how ridiculous my town is. That mulch, which is ground up like wood chips and stuff, was, even though it's permeable and pervious and water goes through it into the ground, was until this day, until 2019, was considered structure coverage in my town. It shows you what we're dealing with. So we revised the application and resubmitted it to the town, removing the garage and recalculating the total lot coverage. So it went from 11.6 all the way down to 8.25 total structure coverage, because now we're not looking to do anything having to do with the garage and we're keeping the existing one that is on the property. We thought that would be easy. Apparently it wasn't.
I guess I have somewhat of a problem with regard to the architecturalist, because the applicant is requesting historic review and approval of plans that aren't indicative of what he's truly asking for.
Well, he's asking for...
Well, the architectural plans still have the enlarged garage on it. So how can the board conduct a hearing with improper plans?
What is it on the architectural plans that is impacting the decision on the house? If the architectural plans just feature a garage?
Because they don't. They're not the plans that represent the application that you got before us now. The plans we have represent the other application you were going to have before us.
Okay.
You could have been easily revised. You could have took out some pages and added the garage that's existing to the plans, but that wasn't done.
But it's not
existing.
It's not uncommon before a planning board or board of adjustment where the plans are revised, either during the hearing or subsequently.
Right, but don't we usually get a copy of those when they're revised? I mean, I would think that what I was going to vote on, I would like to have in front of me. That's my only issue.
Well, many times you can vote based on the plans being revised to show the deletion of the garage, because like Mr. Ferretti just said, it's not going to impact the decision of the board, the architecturals of the garage.
I still showed the garage on one of the pages of my plans. And they said, you know what, we can't hear it like this. We're going to deem you incomplete. We need you to get rid of this page. And I'm like, why would you just fold it over? Don't look at it. You can't look at this plan without seeing that pictured? And the answer was no. However, when David Hansen came in, he's like, I don't even want you to focus on the barn. Just focus on the covered porch. And they approved him without requiring him to come back. That wasn't deemed incomplete. And that's just the one application that was bifurcated. So he decided to do it in two parts. They didn't require revised plans in order to deem him complete. But me, different ball game. Let's waste my time, waste my money, make me reprint, resubmit all this stuff just because they can.
Public hearing on the application of David and Elena Hansen for historic review and approval of bulk variances for construction of proposed overhang on the existing patio.
I just would like a yay or nay. What do you want me to say? We've heard enough testimony tonight.
Let's mark the application, amended application, A1 in evidence, the review application A2, the sheet plan approval engineer entitled site plan site survey, which reflects both the proposed covered patio and the proposed lawn, which is not part of this application this evening.
I'd like to make a motion to approve this application.
Second.
All those in favor?
Yes.
Any opposed? No.
Now, whether acting on that knowledge or not, David Hansen swooped in, and maybe he just has better things to do with his time. He said, Ken, can't we hear this application and deem it complete legally without modifying that one page of the architecturals?
I hear both sides of this, and I'm thinking, legally, can we vote on this? I'm thinking legally. Can we vote on this,
The
Ken?
question becomes, what plan are you approving when you approve the historic review?
It doesn't exist.
Correct.
Right, but are we approving a historical review, or are we approving a house to be built in the variance? I mean, I'm just trying to...
Well, there's two aspects. The variances are one aspect of the application, and the historic approval is the other aspect. They're
Right,
separate and distinct.
right, but can we state it, let's say we do move forward tonight, is it possible to be stated, I'm saying legally, is it possible to be stated that, like we've done in other times where they have to comply with what we're asking, and Craig has things that he has on his list, and will it conform? And if they do not conform, then they do not get a building permit until everything is satisfied. That's my question, legally.
I guess the problem I have is that this item is of such a major consequence to the application that my inclination is to say that there should be a proper plan before the board, before a hearing starts.
I'll ask one more time. Legally, can we do this, yes or no?
Yes.
Okay, that's all I want to know.
But before they even make a determination whether or not that picture of the garage on the one page of the architecturals is going to deem me incomplete or not, we have to get over the res judicata hurdle to see if they're even going to hear the application to begin with, or just end it right here.
The more important aspect of this application would be the res judicata, right?
Correct.
That's the threshold issue, isn't it?
It is.
So if it's determined to be res judicata, then...
Completeness is moot.
That's right, then this discussion...
The waivers are moot.
Everything's moot.
So can we make a motion to table the discussion on whether it's a complete application and move to that res judicata?
We can.
There is no conceivable way that they could consider this now res judicata or being barred by res judicata, because we had a 10% main structure and now it's a 6.83% main structure. There is no conversation, but they still made us go through the exercise anyway. The neighboring attorney made their argument. My attorney made his argument. We've done our submissions, just spending money and wasting time.
My only issue is that the house is exactly the same. And in the resolution that was passed when we denied it, it basically stated the house and the garage. So we denied the size of the house, and we also denied the size of the garage. So being it's exactly the same size of the house, except for a minor difference on the porch, I mean, that's the only sticking point I have in my thought process.
I'm struggling with whether or not, if you're just looking at the house, under the case law, it constitutes 156-foot difference, constitutes what the courts have called a sufficient change in the application itself.
Now, this is David Altman's first application, but he's an attorney, so he knows better. He can read the doctrine and see what the standard is, and clearly look at the two tables and know there's a substantial difference here. He's just playing games, and this is sort of painting the picture of where he's going to stand on the rest of my applications going forward.
I have a question. Was the tunnel part of the garage, or was it with the house?
It was one thing because to connect it, so it made it one solid structure, the whole. That's why it can't. That's why the ground coverage is just such a difference.
But if the tunnel was eliminated, wouldn't that be...
Well, he eliminated the whole garage now.
Right.
With the tunnel?
Yes.
All right. Is that significant?
Well, that's what...
Wouldn't that be... That's pretty significant.
That brings me back. We voted on this. The board voted on this previously. When the board voted to deny it, I'm sure each member had their reasons for denying it. Some might have denied it because they thought the garage was too big. Some might have denied it because they thought the house was too big. I think that's an open question now where the application's different.
I agree with Paul, is that previously for myself personally, I was looking at the whole package. I wasn't separating necessarily house, garage, tunnel, but I was looking at the overall size and scope of the whole thing. I was taking that whole package into consideration. So to me, this
in my mind, this is a substantial difference.
Then Paul Van Dyke, who's the vice chairman of the board at the time, says, can we put a restriction on this guy's property so he can't come back in and ask to make the garage bigger in the future?
Don't we have the right too, that if they're coming before us for a variance, if it gets to the point where we grant something, we can grant it with stipulations? And can't one of the stipulations be that the applicant cannot expand it more than the existing garage?
I don't know if you can do that.
Why not?
I mean, he has a right to bring back.
Or a certain square footage for an accessory building or something like that? Isn't that something that
I think you could
possibly
bring
worked
it.
out?
You could deny it, but I think you could still have the right to bring it. I don't think you could stop him from making an application.
Well, here's my other question. I do believe that he has a right to build a house there. So what is, are we backing him in a corner now where he's put these applications in where his next choice is only to move the house way to the left and build a new house or something that may not be beneficial to a compromise? I mean, I do think that this gentleman is certainly put an effort into to try to get something built, and I think it behooves us to try to work something out with him rather than just keep this going indefinitely.
They're not letting me apply for a garage on this application, but they're looking to prevent me from being able to construct and enlarge the garage in the future without me even putting an application in. That's the whole point. This was never about being fair. They were looking for ways to prevent me from ever having a garage on my property. Why? I have no idea.
On the first application, I was very concerned about the size of the garage and the effect it would have on the neighbor. I do not know, unless Mr. Bell wants to state something for the record, what the neighbor's main objection is to the application. Maybe that would help in decisions, but I think that the gentleman is certainly entitled to something, and I think we should try to resolve it.
Well, that would all be presented after we decide if we're going to hear it or not. So that's really the
I
decision.
make a motion that we hear it.
All right. I second it. I think it's substantially different.
So the net result of this meeting was they deemed my application incomplete because they wanted me to revise the architectural plans to come back, which is frustrating as all hell. But the objecting attorney also then brought up the fact that I was voted down for commercial activity on the property, and he's alleging that the commercial activity is continuing on the property, and suggests that the board should require us to get a use variance in order to proceed. But now the planning board says, well, that's not really our problem. That's an enforcement issue. That's something where you'd go to the building inspector.
If you recall at the last hearings, there were issues about
On this
whether or
application
not-
in January?
The prior application that was...
Prior application.
Yeah. There were issues raised by my clients about the conduct of commercial use at this property, and the board in its resolution found that to be the case. It is our position that that use is still being conducted on the property and in fact in the house itself. And we have proof to that effect that Mr. Ferretti is conducting his business inside the house and on the property with commercial postings, with ads on them on YouTube that have been running up till now. I have dates in January, February, and so it would be our position that if he's going to continue to do that, that he would need a use variance for conducting a commercial use on the premises. Your ordinance does not allow commercial filming, requires a permit. If you're going to do commercial filming, whether it's interior or exterior, but it can't be done under these circumstances in a residential dwelling without a permit. And if he's going to conduct and use this house as a commercial enterprise, then I would submit that he needs a use variance.
At no point in time in any of my applications have I ever asked for permission from the town to film on my property. That is not what I am in before a zoning board to get a house and a garage approved. I'm not seeking anything having to do with filming, their determinations of filming, use variances. I want to make a house bigger and a garage bigger. That was it. Anything that makes it seem like I was looking for their permission to film, this is not the proper setting for it. If they wanted to enforce some form of filming ordinance that they felt I was in violation of, they go to the code official writes me a ticket. I can either pay the ticket or correct the action, or I can go to court and challenge it. Never at any point in time did they give me that option. They used the planning board, and my neighbor weaponized the planning board as a way to enforce or prevent me from doing something that I felt I was legally allowed to do in the town.
Wouldn't the proper channel be that should be filtered through the building inspector first? If he determines that that's a commercial use, then it would come to the board, or it would go to whoever else has jurisdiction on that?
It would be a summons and a violation, and it would be for another venue, not the planning board. It would be for municipal court.
Because if they're bringing this application in, it's not up to us, the police, what they're doing.
No.
Well, I was going to bring that point up, and I thank you that Mr. Ferretti's been there 2 years. He's never received any summons or any complaint from this borough that what he's doing at his house is illegal. I disagree with Mr. Bell. Our position is that this is a residential home. If he takes a video or sends an email in relation to his business, that's not commercial enterprise. And that may be a question for this board to determine. But as of this moment, we have no intention of revising our notice to ask for a conditional use or a use variance to permit this home to be utilized as a commercial enterprise. It's our position it is not.
So we did not look to switch over to a use variance. We revised the plans as requested by the planning board to address their completeness issue. And this just highlights this was never about what I was proposing on the property. It's always been about my YouTube channel, which is foreshadowing what's about to come up. But we revised the plans as per their request, submitted them well in advance of the 10 days required by municipal land use law, and figured we would be good. But then the attorney comes in and says, you know what? You didn't put the species of tree on the plot plan. We've asked you to add these replacement trees on there, and you have the evergreens, the size and the location, but you didn't put the species. I spoke to the planning board chairman, and he says you will be deemed incomplete unless you change your plans. And I'm like, wait a second. First off, I didn't have the species of tree on my last application. It was complete and heard and voted down. Now you're asking me to put the species of the tree. I've got the size and the location and the type of tree, but now you want the species as a matter of completeness. Now this is a twofold thing, because a matter of completeness is not something, it's not a determination by one person. The planning board engineer could make a determination and recommend to the planning board, but it's ultimately up to the planning board to motion and vote whether or not something makes it complete or incomplete. For the planning board chairman to say, if the species of tree isn't on there, it's not going to be deemed complete. It's not the planning board attorney nor the planning board chairman's job to unilaterally make a determination of completeness. That happened here. So I had to then go revise all my plot plans and submit them on a rush notice, which again, it's another $1,000 out of my pocket. You're just stamping money for no reason. And you know what the best part is? The planning board chairman, who, as I remind you, was supposed to put trees in 20 years ago and hasn't, was approved and complete without listing the species of tree on his plot plan. He just had 6-foot evergreens. He didn't say, he showed the location and said they were evergreens. He didn't say what species it is. It's never been a matter of completeness for anybody other than me. And this is now 7 or 8, 9 planning board meetings into this, and all of a sudden the species of tree is now a matter of completeness for me. So here we are in April. We've done all the revisions, jumped through all these hoops, and we're expecting this application to go much quicker from here on out because we've already seen this house for the last 2 years effectively, and we've addressed all their concerns, whether rational or not. We've sort of put the YouTube thing to bed, so we thought, and we expected it to go relatively smoothly. My architect presented our case. My engineer presented our case. I brought in a planner this time who also presented our case and supported the positive and negative criteria and also justified the hardship for the side yard setbacks because of the narrowness of the lot. My neighbor brought in an opposing planner to say that for some reason my house and the setbacks were unreasonable given the constraints of the lot and the size of the lot. I don't know what to tell you, but this just points out that you can pretty much pay anybody as a professional and they'll make an argument. Whether it's BS or not, they'll make an argument for you. To say a 2,000 square foot house or 2,073 square foot house is too large on an acre of property where the planning board's already determined that like a 2,400 square foot house is appropriate on an eighth of an acre, and the most similarly sized lot of 0.91 acres to my 0.94 acres got approved for a 3,500 square foot footprint where I'm going for almost 50% less than what they were approved for. How do you possibly justify that in good conscience? And even my attorney asked the planner, he's like, what size house would the McCormicks be okay with? All you're doing is saying no to everything. What size house do they feel would be appropriate on this lot? And you know what? Couldn't give us an answer.
So your conclusion is that the house as built is not a reasonable use of the property? It's too big?
When you say the house is built, you mean the
The
current house?
proposed house.
The proposed house does not fit on the property, that's clear.
Do you ever have any conversations with your clients, the McCormicks, as to what they would agree to
No.
in terms of a house? Would they agree to any type of house?
I don't know.
Did you ever talk to them about that?
No.
I have no further questions.
Because there is no answer. His answer would be 1,000 square feet is what's allowed by ordinance or required by ordinance. That's what we'd be okay with, which is nonsense. And it's just an irrational response to that. Now, we wanted to complete this meeting this time. My neighbor said he needed more time than was available in the night to have his testimony. So the planning board carried the meeting over till May now. So now we're moving all the way over to May to conclude this application. Started in December, going into May. Very frustrating, but we didn't really have a choice. All right, here we are. It's the main event. It's the 9th planning board meeting. For me, effectively trying to put in something that I submitted 2 years prior that is reasonable on the property, that should have been approved, and we're still trying to get it approved. All of my experts have now testified. My neighbor's expert planner has also testified, and the only thing left was for my neighbor to get up and to give his testimony as a layperson as to why I should be denied for this application. First thing he gets into is that he feels that the house is too large, and then this.
Second reason for our objection to this application is that we believe that the applicant has used, continues to use, and intends to use this property for commercial purposes not zoned for or prohibited in the Rockland Historic District. The board also found this in their denial of the first application, based on the evidence, sworn testimony, and the findings of fact. We continue to object to this application.
Mr. Shaw, I want to interrupt your client right now. He's now talking about a determination by the planning board on facts that existed more than a year ago. What we need to focus on is the current application and what the current facts are. The board doesn't really care what Mr. Ferretti may have done or didn't do a year and a half ago. What's important is what's happening now.
Why is it not important as to what he has done?
Because facts and circumstances could change over a year and a half.
And he's about to introduce those, but to me, it's important. This board made a finding. They made conclusions. Not all of the board members that are here tonight sat on the first application. Those are still facts. We're entitled to have those facts in the record.
But they're facts as to what was in existence a year and a half ago, not today. That's what your client should be focusing on, not what was in the past.
Well, 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 how the tables have turned.
I just have a question. Since this application's been provided, have there been violations going on the property as it exists now? And has any enforcement been done on it?
Yes, there have been violations. No, there has been no enforcement.
Has there been any requests for enforcement?
Well, that I don't know. I don't know if there's been any requests for enforcement.
Just verbally to build the wire.
So my neighbor keeps harping on the use of the property and the commercial activity and the filming, and I'm in violation of the ordinances. And then ultimately, after a lot of back and forth, the planning board chairman says, well, he's not coming in for a use variance, so you can't focus on that.
Our problem is we can only, as a board, vote on what's being presented to us. And there's not anything being presented to us from the applicant that says anything about misuse of the property or asking for a use variance. So, I mean, that's really not what we're going to be voting on.
Well, now, it seems somebody has been schooled in the powers and limitations of the planning board in the off-season. So the board scores a 0 for consistency, but at least now my neighbor is getting a little bit of a taste of the arbitrary and capricious behavior that the board has directed towards me up until this point. They're finally now giving him a taste of what I've had to go through.
My concern is the time lapse between what happened a year and a half ago and now. I think I agree with Mr. Russo that it's prejudicial to the applicant if what occurred a year and a half ago is not occurring now. It should not be before the board. What you can do is do whatever you want to do to support what's going on currently during the pending of this application and what you believe will continue to occur afterward.
But somehow, on my last application, it wasn't prejudicial to highlight the use of my property in Tappan, New York as a justification and a finding of fact to vote me down on my first application?
I understand what you're saying. I respectfully disagree. For example, when there was testimony shown on a slide at the last hearing, the prior application, I should say, where Mr. Ferretti says he's going to do whatever he has to do to get the approval, and after that, you know, he'll do what he wants. The fact that that occurred in the past doesn't lessen the impact of that statement or the intent of it, and I think is admissible here.
But that statement is different than your providing proofs of what he did on the property, as opposed to a statement.
I sort of agree with Mr. Bell here. It just highlights the inconsistency. If you allowed this testimony previously and used it and twisted it as a justification to deny the last application, why are they not allowed to bring the same or similar testimony to this application?
I don't have a problem with what you just said, but I have a problem with using occurrences a year and a half ago to object to what's going on the property today.
Again, on my last application, they used what I did with my property before I put my application in as a justification to deny me, as well as what they alleged I did on my Tappan property in a different state that I was living in prior to even purchasing this property. So the inconsistencies are laughable.
Mr. Ferretti is permitted to continue to use 36 Piermont as a film set, production studio, commercial car storage, a staging area, and sales floor in the Rockland Historic District. And where do you draw the line? Change the name from Ferretti Productions to Netflix, HBO, who also make videos, have subscription content, sponsored content, advertisers, and sponsors.
All right, let's just pause right there. He just compared me occasionally making a YouTube video on my property to HBO or Netflix. Like, the scale and scope of those are like this, but it just shows you how irrational they've been about this entire process. They've got this fictitious detriment in their head that they've created, but my attorney pointed out, you guys don't even know when he's filmed until you've consumed these videos online. So you would have no idea if he's made the video on the property or not until you've seen it as a consumer on the other side of the internet. So how does that bother you?
He's saying that these YouTube videos are somehow affecting his life and his privacy in his house. And the only way he's seeing them is by going and clicking on YouTube.
No, but
Can I interrupt? Just, how does this concern us? Not to be rude or anything, but we're getting on a long tangent with a commercial use and everything. We're a planning board that is either going to approve or deny land use questions. We can put in the resolution that any approvals are subject to the regulations of the town of Rockley, but how do we get involved with policing this?
We don't. We're not an enforcing agency.
So why are we hearing all this?
All right, let's be honest. You guys created this. You've allowed this guy to be irrational, and you've played to the irrationality, and you voted me down on the first one because of it, and now you're complaining that it exists. It's just, you reap what you sow.
I just have a question. I mean, you're showing us that he's doing commercial activity and filming on his property, but yet you haven't pushed it to have any, you know, like, any enforcement done.
Well, so we came here last year, and showed video after video, evidence after evidence of this happening, and nothing happened.
But
Nothing
we're not
happened.
enforcement.
But we,
Why aren't you bringing this to the building inspector and bringing all the information?
We had. And these videos with our property in the background, which this board is completely aware of, as is Bill and anybody else who goes on the internet. I mean, we're not the ones who are the law enforcement, and whenever we told Bill anything, nothing's happened.
Okay, because that's a problem, because we're not the law enforcement aspect of this.
But last year, I came here and showed these same things, and two separate reasons for the denial were made. The board has the authority to not grant the...
I understand what you're saying, but the problem is he's not applying for a use variance to film on the property. Because that, you know, in my personal opinion, I wouldn't approve that. Okay, but that's not the application that's before us. And we can only vote on what's before us. You know, and especially since this has been going on for 2 years now, you're saying, but yet you haven't really pushed to have any enforcement done.
I made these claims previously. They completely ignored it. Now they're taking the same defenses that I made on the first application and they used to vote me down, and they're using it to battle my neighbor on the second application. And then out of nowhere, David Hansen was like, hey, what does the filming ordinance even say?
Where is the ordinance and what does the ordinance actually state? I would like to know exactly what this ordinance states as far as, I mean, we understand as, you know, commercial, inside the house, outside the house. I have to say...
You're talking about the filming?
The filming.
Yeah, it's not under the zoning ordinance, general ordinance.
So 2 years later, a reason that they denied my first application, and something I'm perpetually being accused of being in violation of, 9 planning board meetings later, the guy finally says, what does the ordinance even say?
I think common sense would dictate that if you've been denied for this reason, and he was, that you would discontinue that use. Page after page of this presentation showed usage up to 3 weeks ago of the property for the same things that this board denied him on before. Very specifically denied him on in several paragraphs of your resolution as a separate ground for denial. So we think it's completely relevant to the negative criteria component of the variances that he's seeking.
As I said, they brought this upon themselves. They effed that one up.
If the applicant testifies that he's not using the property for any commercial uses that would violate the Lockley Code, how can we go beyond that?
The suggestion is that if we were to grant him the approvals, it would facilitate the furthering of these videos? Is that really what you're saying? That it would facilitate his ability to continue to run a commercial operation or expand a commercial operation?
Sure. Just, you know, as an example, he's already made and commercial videos, advertised videos on that property, about that property. So the build-out would be great content.
So then my attorney asks him, how does any of this bother you, before allowing me to respond to everything that my neighbor has subsequently said, which I was excited to do.
Dr. McCormick, within the past year, how many times did you personally observe Mr. Ferretti videotaping on his property?
Several times.
When were those times?
I don't remember the dates directly, but you can hear it. Sometimes in the evening you can see the bright lights. You can hear the conversations.
What conversations?
The videoing and the recording of the video.
Everything that you showed tonight, where did you get that information from?
The videos?
The videos.
Online.
Online. Had you not gone online, would you know what Mr. Ferretti's doing on 36 Perk? How would you know that?
We hear it. We saw it. We witnessed it. That's how this all
When
started.
did you witness it? I'm giving you a year. When did you witness this?
I can't give you dates, times. It's just, we witnessed it. And
What specifically did you
we hear the
witness?
noise. We see the lights at night.
What lights? The lights from the
The lights from
camera?
our camera, yeah.
And does that disturb you?
You see it.
You see it from your house?
Yeah. The McCormicks have stated how their privacy is somehow at risk here. That is from the second floor of my house, trying to see their house. Their house, and if you see the third photograph here, the corner of their house to the corner of my house is 309 feet, which is the size of a football field. The allegation that he's somehow in his living room and mistaking me talking somewhere on my property for me filming the video is ludicrous. I can't hear when somebody's on the other side of a football field, and I'm not filming videos. It's me by myself. There's no dialogue. There's no conversation. The statement that the lights are somehow blinding. I don't film videos at night. If I film it, it goes online, and he would have those videos of me filming at night. There's no lights. There's no film crew. It's me and my hand camera. Allegation is that anything I touch becomes commercial, and that's not true. Otherwise, there doesn't seem to be a problem with anything other than me being in the house. It's not going to change my use of the property whether I live in a smaller house or a bigger house.
Oh, no, I agree
It's the
with
same.
that.
And so this argument that somehow by not, and the hope, I guess, is by me not being approved to build that I'll just sell the house. I'm not going to do that. And it just, I'm entitled to, I bought the property, I knew what the property was, I came to the town before I bought the property, I didn't buy it real cheap, I paid market value, if not higher than market value, which is probably over-assessed right now. And I did that with the expectation that I would be able to build by coming in here, seeing the other houses in the town, seeing the look and feel of the town, driving every street in the town, because there's only 5 of them, and seeing, it's like, okay, my vision can work here, and this is where I want to raise my family, I like the property. So I'm not really asking for more than that's already been granted to everybody else that's done in construction. That 6.83% is what my ask is for the house. That's not anything that hasn't been granted for other people.
So yada, 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 summations are over. David Hansen made a motion to approve the application without factoring in anything having to do with YouTube. He just said, I don't think that's something we should be focused on right now. I'm saying that the house is appropriate for the lot, and I think we should approve it. It is then quickly seconded by Peter Lane, who says, I agree, but also I want to say that you're not allowed to do any commercial activity on the property, which then we went back and forth for a little bit. I am putting the links to all of these planning board meetings in. They are long, but if you want to listen to all this nonsense, I try to condense it to make it watchable here, but there's like 9 or 10 hours of testimony on my application here for something that I put in 2 years ago that's already been heard in 4 or 5 planning board meetings previously. So I didn't want to bother everybody with all of this, but if you want to go watch it, fully transparent, you go watch all of them. I'm going to put links in the description to all of these meetings if you want to sit through them. But ultimately, they approved the application with the modification to David Hansen's motion to approve by saying I can't do any commercial activity on the property, which they did not articulate properly, and that led into a prerogative writ lawsuit after I got the resolution, and condition 15 in my resolution said you're not allowed to do any commercial activity whatsoever on the property, but that negates what you're allowed to do for everybody else. Everybody else is allowed to do some home office occupation, and that stipulation then prevented me from being able to do that, and that's where we're going to pick it up next time. Thank you for watching. Rob Ferretti. I love everyone that makes it to this point. I want to give you a hug because there's so much to consume here, and if it entertains you, I love that. If you're learning something, I love that. But also, I appreciate you following along and either supporting or disagreeing with this journey. Either way, I'm glad you're here watching it, and we will hopefully bring this to a swift conclusion soon.